Well, hello there to all the good people of Ohio and beyond. This is Aaron Knapp, and you're tuned into Unplugged, broadcasting without permission. This is a place where the truth gets louder and we dig deeper, and where we always remember be lawful, not awful. If you want the full stories, the documents, the videos, and everything they don't want you to see, head on over to AaronKnappUnplugged.com, my new home for every investigation, every episode, and every update. And while you're here, be sure to like the video, follow the page, and hit subscribe, and share this with someone who needs the truth. We're building something real here. We're building something fearless, and we're doing it together. Welcome to Unplugged. Let's kick this thing off.
Plug with Nap. Yeah, we cut through the noise. No script, no leash, no polished decoys. Broadcasting without permission. We don't ask. We lift the curtain and we drop the mask. Unplug with Nap. Yeah, we cut through the noise. No script, no leash, no polished decoys. Broadcasting without permission. We don't ask. We lift the curtain and we drop the mask. Unplug with Nap. Yeah, we cut through the noise.
All right, happy Friday, good evening there, folks, and happy New Year out there to all of Lorain County, Lorain City, and Ohio and beyond. Hey, folks, I was going to go out and do some roller skating tonight, but my roller skating partner is getting off late from work, and it is what it is, so we're going to do a podcast here about some letters that I received today. So I know everybody was kind of questioning what the letter from LPD was going to be. I thought it was going to be something different than it was. To be honest, I don't really understand what it was. But we're going to discuss that letter as well as another one that I received today in regards to the prosecutor's office. Some interesting happenings definitely going on around here in Lorain and Lorain County for sure on that front. So our first discussion here is going to be about the letter from the police department. So it was like non-existent. Like this is the letter. It's that just this tiny little bit, and basically what it says is they've basically closed the matter or something into McCann. I don't really understand because they don't really have any authority to investigate him anymore at this point. They recused themselves early on. I assumed this was in regards to a request I sent about some statements that were made about Tim Thompson that McCann made that they're saying. But the letter basically, and I'm pretty sure that this is what whoever it was that messaged me and said they thought that, it was going to go away from a fake account, which I believe was McCann, was probably talking about when they were talking about that he was going to get exonerated. But this doesn't exonerate shit. I mean, the letter itself is just a bullshit letter from Fowling and Manziak. And Manziak was involved in all of McCann's, report anyway. So, anyway, the closure before the conversation ever began, right? On, today, but it was they wrote this back on December 18th. I only received it today. The Lorain Police Department letterhead, the one bearing the slogan, duty, honor, courage, and leadership. Something they seem to severely lack in that fucking department. And it was styled as a response to an officer complaint under internal investigation 2025-038. Now, the letter was issued under the name of Chief Michael Fowling, and it was signed by the department on behalf of the department by Lieutenant E. Manixick, who was identified on the same correspondence as the internal affairs investigator assigned to the Office of Professional Standards. Now, that letter told me that the Lorain Police Department Office of Professional Standards, which letters itself abbreviates as OPS, was in receipt of the complaint that I had filed against McCann. But then it moved into immediately some kind of language that's designed to sound like resolution while avoiding any sort of verifiable statement of what actually was done. The letter includes a sentence that sounds empathetic, but it really functions as insulation, right? Because, I mean, again, why would the department that, in their mind, that I fucked give me any sort of resolution after I exposed their little Rivera scheme and it's gotten over 1 million hits online? But the letter includes a sentence that looks like that empathetic statement, but it frames the dispute as my feelings about an encounter rather than as allegations supported by records, communications, and a longer timeline, right? The letter says in substance that, the department prides itself on providing professionally competent police services to the citizens of Lorain. And then they go on to add, we're so sorry you felt your encounter with the Lorain Police Department was not appropriately handled. And after that, the letter delivers the closure, right? It does so in a way that's in a very single, conclusory, conclusion style line that really never identifies what they actually did, what they reviewed, who reviewed it, what documents were pulled, whether anyone was interviewed, whether any conflicts were evaluated. The exact quote is this. However, upon review, I must advise you that the matter described in your complaint does not warrant further investigation. That sentence is not a factual finding, right? It's not even framed as a determination that my allegations were incorrect. It's just an administrative endpoint. It's just the agency telling the complainant that it's chosen not to proceed further without disclosing any of the analytic steps that would allow the public, a court, or any oversight body to evaluate whether the closure was competent, independent, or even real. Or even what the fuck they were interviewing and reviewing. Because they couldn't go back and review that old complaint that their safety service director already blew off. They can't go back and review any of the most recent. All they had was my complaint about, Lieutenant Thompson, now Captain Thompson, running his fucking yap about me like a little bitch who likes to tell lies. And if they don't want to answer it, that's what I'm going to assume. I either assume the chief was lying or Thompson was lying. One of them was lying. And they won't tell me which. But hey, when an agency uses upon review as a substitute for describing the review, it's asking you to accept an outcome while withholding the inputs, right? That matters because the legitimacy of an investigation closure or an investigative closure is not measured by how confident the closing letter sounds, but by whether the process is structurally capable of impartial fact-finding and whether the agency is willing to put the factual basis for closure into the record, right? What the letter does not say, and why the silence is the point, right? The ops letter doesn't say that my allegations were false. It doesn't say that the department gathered evidence that contradicted them. It doesn't say that witnesses were interviewed, that documentary records were pulled, that emails were compared, that timelines were tested, or that the public records I referenced were weighed against internal policy. It does not say whether ops spoke with the subject of the complaint. It does not identify whether any supervisor, outside agency, or neutral reviewer was consulted to mitigate conflicts, right? In fact, the letter never even commits to the proposition that an investigation occurred in any meaningful sense, right? It just simply asserts receipt, offers a generic public relations affirmation of competence, acknowledges my perception, and closes the file with the phrase, does not warrant further investigation. I feel like it should say, go fuck yourself. Anyway, this is why I say the letter was never going to matter, right? Because the design of the letter is not to persuade a skeptical reader that the real and independent review occurred, right? The design of the letter is to create a record entry that sounds final enough to be quoted later as though it was resolved, and it resolved the underlying allegations while simultaneously containing so little substance that it cannot be challenged on particulars. Shit. I mean, I don't even know what the hell they were reviewing. What McCann matter are they reviewing? There's so many. While simultaneously containing so little substance, right? The agency does not specify which records were examined, then nobody can later go prove that the key records were ignored. If the agency and LPD does not name witnesses, then nobody can later prove a witness was never contacted. If the agency does not describe what conflicts were considered, nobody can later demonstrate that the conflict analysis was inadequate, because there's no conflict analysis in the letter to critique. It's closure by conclusory or conclusory language. It's structured to be immune from ordinary accountability. That it's designed that way. When I responded to Chief Fallon, I made the point plainly, because the public has a right to understand what an ops review means. When the subject is a former chief and the department has already lived through a major internal scandal in which the retaliation allegations against that same chief were central, I said I did not accept any implication that the matter was subject to an independent, impartial, or structurally sound review. And I did not say that as rhetoric. I said it because the structure described, right, by the department's own recent history makes independence impossible to assume. Why this review was structurally impossible to be independent was, and the reason this letter was never going to matter, has nothing to do with whether or not an individual investigator, is polite, or whether any specific person thinks they are acting professionally. The reason it was never going to matter is structural, right? Because the same internal systems that had already recently investigated McCann in a high-profile retaliation matter were now being used to dismiss a separate complaint involving the same former chief, and the overlap was not hypothetical. It was visible, documented, and it was stamped on the face of the correspondence itself. In my response to Chief Fallon, I anchored this in what the department had already done in the Middlebrooks matter, right? I wrote, Lorain Police Department's Office of Professional Standards recently completed Internal Affairs Investigation IA 24-27 concerning Lieutenant Corey Middlebrooks. And I described why that matters, because that investigation confirms that ops investigators, internal command staff, and departmental witnesses were extensively involved in examining allegations of retaliation, discrimination, and abuse of authority by then Chief McCann. I also stated, based on the way that the department itself structured that internal case, that the Middlebrooks report confirms McCann ordered the investigation, delegated authority, submitted written responses, and was interviewed, and that ops investigators relied upon sworn personnel from the Lorain Police Department as witnesses and sources of that information. That's precisely the context in which a later ops closure of a separate McCann complaint becomes structurally compromised, right? Because the investigator is not an outsider, the witnesses are not independent, and the institutional relationships are exactly the same. The conflict's not the department knows its own policies. The conflict is that the department is asked to adjudicate allegations about its former command structure using its own employees as both investigators and witnesses, and then it expects the public to treat that as independent because the letter uses the word review. I'm not asking for faith. I'm asking for a process that deserves it, right? The whole manic overlap, and why it undercuts public confidence, is that the overlap makes this impossible to ignore. It's the presence of Lieutenant E. Manasek. In my response, I stated, the point is the clearest way that the public can understand, because the overlap is not hidden in a footnote. I specifically wrote to them. Notably, Lieutenant Mansiak served as the IA investigator through the Office of Professional Standards in the Middlebrooks matter, and is identified in the ops report as acting in that investigative capacity. The same Lieutenant Manixick or whatever is now the signatory on the correspondence, now informing me that my complaint against McCann does not warrant further investigation. That's not a coincidence of staffing, folks. That's a structural problem that undermines the public confidence, even if every person involved believes they acted fairly. When an investigator has already participated in a command level investigation involving the same chief, where the investigator's work product is part of an existing public narrative and the administrative record, it is unreasonable to present that same investigator as a neutral decision maker in a subsequent closure involving the same subject. Even if no actual bias exists, the appearance of bias is sufficient to erode trust. And that public is not required to pretend otherwise simply because the letter is written on official letterhead. Duty, honor, and trust my ass. In the same response, I said something else that matters because it frames the issue honestly, right? I told Fallon that the issue is not the professionalism or the intent of any individual, investigator. I clarified that the issue is structural conflict. That distinction is important because it prevents the agency from reducing the criticism to personality. It's not whether Lieutenant Manciek is a good person. This isn't about whether the department can credibly investigate itself when the subject is the former chief and the same internal apparatus and investigator remain in control. What the letter carefully avoids saying, and why that is a mechanism, that evasion is a mechanism that the ops letter does not state, because it doesn't state that my allegations were unfounded, right? What it does not state is that they were disproven. It does not state that the evidence was reviewed and contradicted. It does not identify what records were examined, what witnesses were interviewed, or even what steps were taken to mitigate conflicts inherent in the investigating a former chief of police using internal personnel. That absence matters because it means that the agency is not asking the public to believe, like, it's asking the public to accept the conclusion while remaining ignorant of the whole process. What I wrote back made that point explicitly when I said your letter does not state that my allegations were unfounded. It does not state that they were disproven. It does not state that evidence was reviewed and contradicted. It does not identify what records were examined, what witnesses were interviewed, or what steps were taken to mitigate the conflicts inherent in investigating a former chief of police using internal personnel. It states only that the department has chosen not to proceed further. Ooh. I do the line that the institution does not want drawn, though, because it strips the closure letter to the authority it wants to project. I wrote that is an administrative decision, not a factual finding. I said that because the word review can be used as disguise in the absence of review, but a factual finding requires a disclosed basis. A factual finding requires something that can actually be tested. An administrative closure can exist without any of that. And in this instance, the department chose the form that is least accountable, administrative. But it doesn't really end anything. Administrative closure doesn't negate documentary evidence. It doesn't extinguish disclosure obligations. It dang sure doesn't exonerate anybody, like whoever that freak was that emailed me. Administrative closure does not bind prosecutor courts, the Ohio Attorney General, the auditor, or oversight entities that later review the matter. You know what cracks me up about that is that the person that claimed to know that they were going to get exonerated, this fake name that I've often associated with Mr. McCann or with Ms. Hilton, this person obviously had inside knowledge because on the day that this was written, I believe it was almost to the day, this individual was messaging me claiming that McCann was going to be exonerated. So they obviously are a member of the police force. Who knows? Maybe it's even Lieutenant Manciek. I don't know. I don't know who it is because they're using a fake name. Whoever it is knows enough about this decision to claim that they're gonna have a happy new year and that basically this decision he's gonna be exonerated. Happy New Year and Merry Christmas and go fuck yourself in the new year, something like that. I mean, they had inside knowledge. The LPD has a leak. These fuckers talk. And whoever this was that was messaging me from a fake account on my email address about this obviously had firsthand knowledge that this was going to come out. So LPD doesn't even have control over its own people. They just loose lips, sink ships, and suck dicks, I guess. I don't know. Not bind prosecutors, courts, or Ohio Attorney General, the auditor. Any oversight entity that later reviews the matter are not bound by an administrative closure, right? It doesn't prevent external agencies from reopening or reviewing this conduct. Administrative closure simply means the department is finished with it itself, right? It's like, hey, I'm done. And the public is expected to treat that as a resolution, or at least I am. I preserved that principle in plain language when I wrote an internal closure letter does not negate the existence of documentary evidence, third-party communications, or public records. It does not extinguish disclosure obligations under Ohio law. It does not foreclose external scrutiny. It does not resolve credibility questions that OPS itself has previously recognized require extensive examination when allegations involve the chief of police, right? That paragraph is the heart of why the letter was never going to matter, because the department uses closure language to imply finality, but the underlying evidentiary issues do not become less real simply because ops chose not to proceed. Records do not stop existing because the police department decided not to look at them. Patterns do not stop being patterns because an internal office decided that it had seen enough. And conflicts do not stop being conflicts because an agency refuses to describe how it managed them. The real function of that closure letter was to give the institution something it can cite later. It creates a line in the sand and allows them to say ops reviewed it. Even though the letter does not really describe any review steps, it allows them to say it did not warrant further investigation. Even though the letter doesn't explain the warrant standard was used, it allows them to move administratively while leaving the complainant to carry the burden of proving what the institution chose not to put into the record. That's why I said in my response that if the department's position is that the allegations against the sitting or former chief can be investigated and dismissed exclusively by the same internal affairs investigator and same department apparatus previously involved in related command level investigations, then the department should state plainly and defend openly that position rather than implying independence through conclusory language, suggesting resolution where none has occurred. In other words, if the department wants to argue that self-review is enough, then it should make that argument directly. Stand up, be a man, grab your little nutsack and tell us all, hey, we made this decision. We believe we have enough non-ambiguity and enough impartiality to review a guy that dominated us for decades. But hey, because the public does have a right to evaluate that, the department should not be allowed to smuggle that position, right, into a record using a letter that almost says nothing, right? But hey, this is just the first visible closure in a longer chain, right? I want you guys to understand that this letter is not the whole story. It's not the end of the story. Hell, because the letter itself is not even actually the first visible institutional closure in this chain of resistance. It's a moment that where the internal system signals it's not going to self-correct, right? And this is when Fallon and Crew are saying, we don't give a fuck. That's when the moment of the conflict shifts outward, right, into other forms of retaliation and counterattack. This is why the story moves from the police department closing the door with the phrase, it doesn't warrant further investigation, to the prosecutor's office escalating disputes into character attacks, to the weaponization of licensing and disciplinary processes, and to the broader pattern where the government actors stop answering the substance and start attacking the person who forced the substance into daylight. You know, we're starting to hear a lot of repeats in my podcast about daylight, sunlight, daylight, sunlight, daylight, sunlight. That's why this part, one matters so much. It shows the mechanism, right? It shows the posture. It shows how institutions use administrative closure to avoid factual engagement. I want you to see that the next chapter, the whole Prue chapter, stops looking like an isolated dispute and starts looking like what it is. Continuation of the same resistance, just in a different venue with a different tool. And by a different tool, I definitely mean with a different tool. She's a tool, he's a tool, they're all tools. Before we get into a part two here, that brings us to the start of part two, and I'm going to go ahead and pause real quick for a quick station identification. Hey there, folks. Aaron here at Unplugged with Aaron Knapp. I want to give you a quick reminder for everyone watching that the City of Lorain holds its regular City Council meetings on the first and third Monday of every month. And those meetings are not just for council members, they are for residents. If you care about what happens in your city, and if you speak or want to speak on an issue, ask a question, or simply be present and informed, showing up matters. Participation matters. Even sitting in the room and listening matters. You do not need to be an expert on any of this. You do not need permission to care. You do not need to do anything other than just show up. So check the agenda, folks. Mark your calendar. And if something affects your neighborhood, your family, or your future, take a seat, raise your hand, and make your voice part of the record. Lorain City Council, first and third Monday. Your city, your meetings. Those council meetings start at 6 p.m. Eastern Standard Time, and they're held inside of City Hall. Make sure you attend this Monday's meeting. Hey there. All right, folks. That's right. This Monday, I believe there is a meeting to be the first Monday of the new year. We'll have our new council in place. We'll have a bunch of new faces. So go ahead and check that out. This Monday at 6. So part 2 brings us from internal closure to external retaliation, right? We're going to enter the prosecutor here, who cannot be neutral. While the Office of Professional Standards was quietly preparing to close its file with a conclusory sentence that submitted administrative finality for factual engagement, a parallel conflict was already unfolding outside of this whole conflict with the police department, and it was with the county. Now, the conflict didn't arise by accident. It didn't arise in a vacuum. It unfolded inside the Lorain County Prosecutor's Office. And it mainly unfolded through the actions of Assistant Prosecuting Attorney Lee Prue. Now, it's important to be precise about how and when the relationship between Lee and I formed, because it did not begin with a habeas corpus petition with James Mauricio, a filing deadline, or a disagreement over a legal theory, right? The relationship between Ms. Prue and I developed over a year prior in an adversarial contact in public records litigation, open meetings disputes, and related proceedings in which I challenged the government conduct lawfully on the record and with documented success. She was the final documented lawyer in the case where I won against the county. She was the one that helped with Robert and I putting together the final disclosures on that. So in those matters, I was not a casual complainer, or a rhetorical critic. I was public records requester and a litigant and a party invoking rights expressly granted by Ohio law. That's clear. The history matters because neutrality is not an abstract concept that only appears when a new case caption is opened, right? Neutrality is about whether an attorney recognizes when prior adversarial engagement, repeated credibility attacks, and personal entanglements make continued participation untenable. That ethical obligation to step back does not depend on whether a judge has already issued a rebuke either. It depends on whether continued involvement undermines, confidence in the fairness of the process. I recognize the problem, but I raised it directly. I asked for Ms. Prue's recusal. And I didn't ask casually either. I didn't ask rhetorically. I asked because by that point, she had already accused me in court filings of dishonesty. She's made statements. Basically said that I was making false sworn statements or acting in bad faith. Those accusations were not accompanied by any judicial findings. No courts determined that I've lied. No tribunal sanctioned me. No licensing board, more importantly, has made an adverse determination against me. Yet the accusations were placed into an official pleadings as like they were statements of fact. Now, when an officer of the court, especially an assistant prosecuting attorney, accuses a licensed professional of dishonesty under oath, right? She wrote it in the court record. Without a finding to support that accusation, the harm is not theoretical, it's reputational. It's professional. Follows the person beyond the four corners of the case in which the allegation was made. as to precisely the kind of conduct that triggers heightened ethical scrutiny, because prosecutors are not private advocates free to say whatever, advances their position. Prosecutors are the ministers of justice whose words carry institutional weight. That's the core context in which this whole next sequence unfolds. We start looking at it from the 7-day clock, right? That tells the whole story. Because on October 6th of 2025, I formally wrote an email. I notified Ms. Prue and her supervisory authority, Mr. Solo, that her filings mischaracterized my role and falsely impugned my credibility. I did so in writing. I did so on the record. I have the record. I have the emails. I did so in a way that preserved the issue for review rather than inflaming it through public accusation. I identified the problem and I asked that it be addressed, right? Clear, simple. I CC'd my attorney. I think there was only like 4 or 5 people involved in that email chain. Now, that's key. Because, right, that was on the 6th. 7 days later, on October 13th, Ms. Prue files a complaint against me alleging unauthorized practice of law, UPL. That timeline is not speculative, right? It's documented. It's in the paperwork. And it matters because nothing else changed in that 7-day window. No new facts emerged. No court issued a finding against me. No judge referred my conduct to a disciplinary authority. No opposing party filed a grievance. No licensing board requested clarification. There was no external trigger that would ordinarily explain a sudden escalation into a disciplinary complaint. The only intervening event was that her conduct had been challenged. That's not a coincidence, folks. That's a sequence. And sequence matters in this retaliation analysis because retaliation is rarely announced. It's inferred from timing, from escalation, from the absence of alternative explanations. When a person raises an ethical concern about a prosecutor's conduct and it is met with days later with a disciplinary complaint based on the same body of work that existed before the concerns were raised, the interference does not require imagination. It requires only honesty about how institutions respond when they get challenged. What followed was not a neutral referral, folks, driven by judicial concern. Lee didn't give a shit about that. It was an offensive maneuver deployed after a recusal request, and it carried the unmistakable signal that challenging the prosecutor would come at a personal cost. The complaint did not arise from some, unauthorized practice of law. It arose from lawful participation in judicial proceedings, expressly permitted by statute and rule. And it was framed in a way that attempted to recast advocacy and record-based arguments as professional misconduct. Damn. That move mirrors the mechanism already exposed in part 1, right? That's McCann's playbook. When internal review becomes inconvenient, the institution does not engage the substance, right? It changes the forum. When factual rebuttal becomes difficult, the response shifts from evidence to character. And when it goes from there, when transparency produces discomfort, well, then the system does not correct itself. It hardens. That's why you can't look at this part 2 here, and it can't read it as a separate dispute or a personal feud. It's the next logical step in the same institutional response pattern. The police department closed its file without findings. The prosecutor escalated into disciplinary attack without new facts. Different offices, different tools, same posture. Still tools. Once you understand that, the story stops being about isolated decisions and starts being about how power reacts when it's forced in the open. That brings us to part 3, where Ohio law actually says about UPL, unauthorized practice of law, which I'm real careful to never do. The definition of the complaint, that this complaint she made can't escape, right? UPL, unauthorized practice of law in Ohio, is not defined by your vibes, by impressions, by discomfort about who's speaking, right? It's defined specifically. I've read this multiple times to make sure I never cross this fucking line. And even in social work school, when we talk about how the law relates to us, they make sure you make sure your clients know that. You're offering it up as your understanding of the law, of how, the law affects your systems and the interaction of the systems, not an offering law advice to anyone ever. But when we look at UPL, it's defined by the Supreme Court, and it's defined narrowly. The narrow definition is not accidental. It exists precisely to prevent the kind of abuse that occurs when advocacy, clerical assistance, or citizen participation is retroactively recast as professional misconduct, which is what we have here. Ohio law does not define the practice of law as typing, formatting, proofreading, drafting under direction, or assisting counsel. Ohio law defines the practice of law as the application of legal principle and independent legal judgment to the circumstances of another person. Kind of like someone did in a recent podcast. When you offer up advice to someone else and say, hey, da, 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 da. That definition comes directly from Ohio Supreme Court's decision in Cleveland Bar Association v. Comp Management, Inc., and it's been reaffirmed repeatedly across the decades of unauthorized practice jurisprudence. Now, the court's been explicit that the critical factor is not whether legal language appears on a page. And again, I'm reading this, no legal advice being given, but the legal language appears on the page, but about who exercised the discretion, who made the strategic choices, who assumed responsibility for advising a client or directing a case. The line the court draws is between independent legal judgment and mechanical or ministerial assistance if that activity is performed at the discretion of a licensed attorney. And if the licensed attorney retains control over substance, strategy, and representation, then the activity is not the practice of law. The distinction is not controversial, right? This is not unsettled law. It's the foundation of how every law office in Ohio functions. Paralegals, legal assistants, investigators, clerks, they exist because the law recognizes that not every task involving legal documents is legal judgment, right? That's key. Not every task involving legal documents is legal judgment. That's key because not every task involving legal documents is legal judgment. And if it did not, the modern practice of law would be literally impossible. The complaint filed against me cannot escape the definition because it never alleges that I exercised independent legal judgment, right? Instead, it attempts to redefine clerical work as lawyering by stripping context, ignoring supervision, and conflating authorship with authority. What I did and did not do in regards to this whole habeas corpus thing is it would be the easiest way to understand why the complaint fails to be explicit about what I did not do. I did not hold myself out as an attorney at any point in any form to any person, nor am I. I did not use the title attorney, counsel, or equivalent designation. I did not appear in court as counsel. I did not communicate with the court as counsel. I did not sign pleadings as counsel. I did not file documents as counsel. I did not serve documents as counsel. I did not advise a client about legal rights or remedies as myself or counsel. I did not decide litigation strategy. I did not determine what filings were required or when they were due. I did not negotiate with opposing counsel. I did not make representations on behalf of a client to any tribunal. Those functions were all performed and belonged to attorney Robert Gargas. I advertised for him on occasion. He's a good attorney. Mr. Gargas appeared as counsel of record in this matter in both cases, both when he first started it and basically he was my attorney. And I filed for a waiver of fees because I'm indigent. And I can do that. Mr. Gargas was pro bonoing his fees for me, and I was filing indigent. That's lawfully allowed. But Ms. Prue immediately attacked that premise that I was even allowed to be a next friend which we'll get to later. So Mr. Gargis was forced to refile because they basically dismissed their first filing with me as the next friend. While they were doing that, Garen was able to go down to the jail and bring an actual notary to the jail because they just didn't have any apparently available, even though they should have, for him to actually, swear on his own behalf. So then he actually authorized me to be his next friend and Mr. Gargis to be his attorney. But by that point, it didn't matter. What he didn't know and what he couldn't know and I didn't know is that once, I kind of knew once he signed an affidavit asking Mr. Gargis to be his attorney, my role ceased. My only role up until that point was because he had no access to anybody else to get him access to an attorney. I had access to an attorney, and I'm a social worker, and I made that connection happen. Mr. Gargis was my attorney. We filed the case on behalf of Mr. Mauricio, or at least attempted to. The court, through lead rejected it 3 days later or whatever, and Mr. Gargis refiled a new case number that he was forced to pay for. And then, mind you, and then they tried to come back later and charge him for the case that I brought, as if somehow they believe that he should have to pay for the case that got dismissed. No, that's not how this works. Just because he's an attorney doing pro bono work for me doesn't mean you get to sack him with any fees that you would have assessed to me because I got a waiver. It's not how it works. But Mr. Gargis appears as a counsel of record. He assumes responsibility for the case. He exercised all the legal judgment. He determined the substance. He approved the language. He signed the filings. He communicated with the court. He represented the client. He controlled the litigation. That's not disputed. It's not even ambiguous. It was all right there in the court record. Any assistance that I gave was typing drafts into a word processor at the discretion of a licensed counsel. I assisted with formatting, organization, transcription of arguments that were reviewed, revised, approved, and adopted by counsel of record. It matters because that's just clerical assistance. It's the same assistance provided every day by paralegals, assistants who support staff all across Ohio. It sounds like the complaint attempts to convert the act of typing into the act of practicing law. That's insanity. If that theory were accepted, it would criminalize routine law practice throughout the state. It would mean everyone and anyone who drafts under supervision, even when the attorney retains full control and responsibility, is engaging in unauthorized practice. The Ohio Supreme Court's rejected that theory repeatedly because it would collapse the distinction between judgment and mechanics that the law deliberately preserves. And then one of the things she says is, it looks like you wrote it. The whole fallacy of the central claim embedded in the complaint is not legal at all. It's stylistic. In her complaint, she suggests that certain filings resemble my writing style, and it attempts to alleviate that resemblance into evidence of unauthorized practice. That argument fails as a matter of law. Ohio does not ask who typed the words. Ohio asks who exercised legal judgment. Style is not authority. Voice is not representation. Familiar phrasing is not legal advice. The presence of consistent syntax or tone proves nothing about who controlled the case or who assumed responsibility for legal decisions. If appearance alone were legally sufficient, every paralegal who drafts pleadings, every assistant who prepares motions, and every clerk who formats filings would be subject to discipline. That's not how Ohio or really any state's law works. Has never worked that way. Courts look at the substance, right? Not aesthetics. They look at control, not authorship. They look to responsibility, not resemblance. The court complaint, or this complaint, actually ignores that framework entirely because it has to. If it engaged honestly with the controlling definition of unauthorized practice of law, it would collapse under its own weight. That's why this complaint is not merely weak. It's structurally incompatible with Ohio law. From an attorney, mind you. Jesus. It attempts to expand unauthorized practice beyond recognition not because the law supports that expansion, but because the accusation serves a retaliatory purpose, right? Smacks back in. Once that purpose is understood, the complaint stops looking like an effort to protect the public and starts looking like what it is, an attempt to punish lawful participation in the judicial process by rebranding it as misconduct after the fact. That's why Part 3 matters so much. It grounds the discussion where it belongs and what Ohio law actually says, not in what is offended in official wishes it says. Whatever offended official wishes it says, right? We kind of roll into this next part. The whole misuse of this next friend and the habeas document. I don't understand how they don't understand, but friendship's not a legal requirement when the complaint's fixation on the word next friend, right, is not some neutral language, or it's not a neutral legal argument, right? It is a deliberate mischaracterization of habeas doctrine that substitutes social familiarity for the actual legal standard. It does so in a way that ignores both controlling federal law and procedural history of the case itself. Under habeas jurisprudence, next friend is a term of art, right? It's like Michelangelo and the Sistine Chapel. And it never was meant to be used in that way. It doesn't mean friend in the ordinary sense of the word, right? It doesn't require and never has any sort of personal friendship, any ties, any family relationship, or any prior social connection between the filer and the restrained individuals. The United States Supreme Court's been explicit on this point. The inquiry is not functional, the inquiry is functional, not relational. And it exists to ensure access to the courts when a detained person cannot meaningfully act on their own behalf. The governing questions are narrow and well-settled questions. The court asks whether the petitioner is restrained of liberty, whether the petitioner is unable to litigate effectively on their own due to incarceration or other incapacity, and whether the next friend is acting to facilitate access to judicial review rather than to advance personal interests. That's the law. Those criteria are what meets the law standard. They're not optional. They're not supplemented by an unwritten requirement of friendship or buddy-buddy. Doesn't mean we hold hands, skip to our loo. In this case, those criteria were met at every relevant stage of the game. The petitioner was incarcerated, yes. James was in jail. He was in the county jail, and he did not have access to meaningful notarial services and legal resources within the jail. And we know this, and their own process shows this, because initially when Garen went down there, was trying to put money on his books to get them, and usually they got at least one jailer on duty at night that's a notary, because they do have people that want to do this stuff, and they have to have them available. The county jail, had no notaries, and continued to have no notaries substantially while we were trying to get him a notary, which is why she felt ballsy enough to write this and other statements at the time, because she didn't think we'd get one. But Garen found one, and he brought that notary down to the jail, and that notary got sworn statements from James. Now, the whole point of that is once he got those sworn statements, I was out. They had dismissed the case against the first case where I was next friend against James, and I was out, so nothing more to do with me. In fact, I was out long before she wrote this complaint, long before she wrote any of this stuff. So yeah, he had no access to a notary. The initial filing was made to preserve access to the court, right? Not to substitute my judgment for his will, not to advance any personal agenda. And that's precisely why the circumstances in the next friend filing standing exist, right? Her argument was that the dad reached out to me. I gave her the copy of the dad reaching out to me and whatnot. But I had a prior connection with this guy prior to dad reaching out to me. He'd asked me to advocate on his behalf. And I keep our relationship at arm's length for a reason, whereas Garen keeps it more friendly, familial. I keep it more at length so I can be a good advocate for people. If I start being friendly with everybody, we got a bigger problem. Because then I can't be an advocate for anyone if I'm friends with everyone. These create conflict of interest. This is why judges, cops, and other people don't have a lot of friends unless they're also judges and cops. Why would you? It just weakens you. But the initial filing was made to preserve access to the court, not to substitute any judgment, right? That's why this process exists. And it matters here because the complaint attempts to freeze the analysis at the earliest filing when ignoring everything that follows. Initially, I was listed as next friend because the jail did not have a notary available to James. That was it. And as a result, I was sworn and notarized as next friend in order to permit the filing to proceed at all. So he contacted me. I talked to him, talked to his dad. I got notarized. I went to my attorney. My attorney agreed to represent the guy, but he had to do it through me as the notarized next friend. That was not a strategic choice. It was a practical response to institutional constraints inside the jail, and by law it was required. APA Peru objected to that filing initially, right? And the court dismissed that version of the petition in which I was listed as the next friend. They claimed I had no standing. They claimed this. They claimed that. Didn't really matter. It doesn't even really matter what they claim now. The bottom line is that it's gone. New case number, right? Totally new case number. I'm not involved in this, but they objected to it at the time. Said that basically Robert was refiling basically the same thing over again, which if I recall correctly, and I don't know because I'm not a lawyer. I read it. It didn't seem like he was filing the same thing because the first time around we were filing it as a next friend, and the next friend is just me in lieu of James. Well, once James was able to get notarized and was able to get that in place, then everything changed because now he's able to authorize Robert to be his attorney. And at that point, I'm out. Prior to that, Robert was my attorney. At that point, I have no more business involved in this other than just chatting with James and talking to him about stuff, right? And I sure wasn't giving legal advice. Occasionally, I passed on knowledge that Bob asked me to pass on to him because James would call either me, Garen, or Robert because he had limited phone time. We'd have to get out and put money on his books. So whichever one of us he got hold of, we had standing instructions to talk about. But when I got called, I kind of got a little weird and funny about it because I don't like being recorded. I start the call out because it starts out with you're receiving a call from a penal institution in the state of Ohio, but it gives like the company name and all this other stuff. I was being an asshole when it popped up, and I was just like, you hear me in the beginning of the recording because I've heard the recording of the call with me and James, and you hear me say like, yeah, whatever, I don't give a shit. And then NLX or whatever company it was. Like I was being a jerk. I knew the call was recorded. It was very clear. I was making just in light of it. But the procedural matter, record matters here because the complaint attempts to freeze that analysis, those early filing stages. And, after they dismissed it, there was no, they didn't find me to have committed misconduct, unauthorized practice, or bad faith. It was a procedural disposition tied to standing and form and not an adjudication of wrongdoing. What happened next is the dispositive. What happens next is dispositive and is fully documented in the case file. It's not dispositive. It's dispositive. Anyway, following the dismissal, arrangements were made for a notary to enter the jail, right? Or right about the same time, almost exactly the same time, because they had filed for the dismissal. They had asked for it. And the petitioner executed sworn, at that point they asked for the dismissal. We saw it coming. So Garen, found somebody to go. He hot tails it down there. He files the dismissal with getting arrangements made with this notary to go in the jail. The petitioner executes the sworn statements authorizing Robert to act as counsel. Like I said, at that point, I'm done. At that point, Gargis takes over. He was already counsel of record for me, and now he becomes when I was the petitioner, basically, and now James is the petitioner. Well, again, not the petitioner. I was the next friend, but it puts me in the spot of acting on behalf of the petitioner, only in the fact that it's like you're a fill-in body. You're just a warm body until the petitioner arrives. You're not practicing law. Robert is. Now, I was no longer acting in any next friend capacity in any sort of live filing, right? In other words, the procedural posture changed in ways that cures the very issue that the complaint that she made pretends remained unresolved. In the first filing, Attorney Gargis was counsel and I was listed as next friend due to the petitioner's lack of notarial access. In subsequent filings, Attorney Gargis was counsel for the record for the petitioner himself, and the petitioner was the actual client, James. That distinction is not semantic. It's structural, and it's reflected plainly in the docket. It's there for all of the world to see. At that point, any continued focus on whether I was a friend of the petitioner ceased to have any legal relevance, even if such a requirement did exist. And it didn't. The petitioner ratified the filing. The petitioner authorized counsel. The petitioner affirmed the assistance request. There was no ambiguity left for the doctrine to resolve. The complaint's insistence on relitigating the meaning of the word next friend after those facts were on the record is not really a legal analysis. It's misdirection. It attempts to transform a procedural mechanism designed to protect access to the courts into a character test that the law does not recognize. Habeas doctrine does not ask whether the filer was socially close to the petitioner. It asks whether this filing served the petitioner's access to judicial review. In this case, it did. By ignoring the sworn affidavits, the subsequent filings, and the shift in representation, the complaint reveals its purpose. It's not to clarify habeas doctrine. It's to manufacture a narrative of impropriety by isolating an early procedural moment and stripping it of context. When the full record is examined, the next friend argument collapses under its own weight. Like, the timing problem that the complaint cannot explain is what ultimately exposes the misuse of the next friend doctrine. It's not abstract law, it's timing. And by the time this unauthorized practice of law complaint was filed on October 13th by Lee Prue, I have the date. The procedural issue the state now claims to be alarmed by no longer existed. It had already been cured on the record, in the open, through sworn affidavits and a change in representation that left no ambiguity about who the client was and who the attorney was, and who controlled the litigation. That matters because disciplinary processes are not designed to resurrect procedural defects that have already been cured or resolved by the court. And I'm not saying that it was a defect. I'm just saying it was resolved. They're not retroactive enforcement tools. They're not vehicles for relitigating dismissed filings once the case is moved on under proper representation or under representation. If the next friend issue were genuinely disqualifying, right, it would have been dispositive. There we go, dispositive. At the moment it arose, not weeks later or months later in this case, but I didn't get it for a while. After it's been almost 90 days to the day. After counsel of record had appeared, affidavits had been executed, and the petitioner had been released from custody. The sequence is not in dispute. The initial habeas corpus filing listed me as next friend because the petitioner was incarcerated and lacked access to notary. The state objected. The court dismissed that filing. While that was going on, Garen was getting a notary to the petitioner, to James, and afterwards the notary, all right, no. So then a dismissal occurred with my initial filing. That resolved any issues that we have of any sort of UPL that she might have been claiming occurred, which wasn't. Afterwards, the notary enters the jail. The petitioner executes the sworn statements, and now Attorney Gargis appeared as counsel of record for the petitioner himself, as opposed to representing me in the next friend matter. he was really still representing James. James told me anyway. Counsel of record for the petitioner himself. From that point forward, the next friend controversy to litigate because there's no next friend in control of the live case. It's done. It's over. Bye. The UPL complaint did not arise at that moment. The state objected to the initial filing. It did not arise when the court dismissed that filing. It did not arise when the affidavits were executed. It did not arise when counsel entered an appearance. It only arose after the case had progressed through proper channels, under proper representation, and after I formally challenged Ms. Prue's conduct and credibility in writing in an email to her boss and her. Timing is not neutral, folks. It's diagnostic. Revival after cure is not law enforcement. Ohio's unauthorized practice framework is concerned with ongoing conduct that substitutes non-lawyers for licensed counsel. It is not concerned with cured procedural posture in a concluded phase of litigation. Once counsel of record is in place and the petitioner is the named client, the law doesn't permit the state to rewind the clock and declare that in an earlier dismissed filing retroactively somehow taints everything that follows. Yet that's exactly what the complaint attempts to do. It treats the next friend label as though it were frozen in amber, ignoring the court itself rejected the filing and that the parties proceeded correctly afterwards. The complaint relies on a snapshot that no longer governed the case and uses it suggesting ongoing misconduct where none existed to begin with. Now, this is not how neutral enforcement works. Move this up a little bit. Neutral enforcement responds to live violations, right? Retaliatory enforcement resolved issues only after the target has become inconvenient. The doctrine was not revived because of new facts. It was revived because the criticism was no longer confined to the pleadings. That's it, guys. That's it. Like the retaliatory function of the doctrinal resurrection. That's the most telling aspect of the complaint. It's not what it argues, but what it alleges. The next friend argument didn't suddenly become more troubling after it was cured. It became useful after my written notice to Ms. Prue and her supervisor, Mr. Solo, that her filings mischaracterized my role and falsely impugned my credibility because she called me a liar. And 7 days separates those two events, folks. 7 days. 7 days between formal notice challenging her conduct and the filing of a disciplinary complaint built entirely out of arguments the court had already mooted. That's not enforcement following discovery. That is escalation following resistance. When doctrine is revived only after the underlying issue has been resolved and only after the filter has been criticized, I think that the purpose of the revival is no longer to protect the integrity of the courts. It seems like it's a reframe of a procedural disagreement as professional misconduct. Maybe I'm wrong. Now, if it is to move the dispute out of a forum where facts are tested and into one where reputation itself becomes the battleground, then why the court's disposition matters, court, is that courts dismiss filings all the time. Dismissal is not discipline. Dismissal is not a finding of deceit. Dismissal is not implicit referral for unauthorized practice. If courts believe the next friend filings by non-lawyers constituted unauthorized practice per se, habeas doctrine would collapse under its own weight. Because the doctrine exists precisely to allow third parties to act when prisoners cannot. Here the court didn't what courts do. It addressed the procedural posture, dismissed the filing, and allowed the case to proceed under corrected circumstances under a new case number. It did not issue sanctions. It did not refer the matter for discipline. It did not accuse anyone of misconduct. The state's later attempt to transition that dismissal into evidence of unauthorized practice is not supported by anything the court said or did. It's basically just her trying to be a dick to Bob. She went after him too, mind you, just separately. I have a party that matters, so I don't know. But in mine, he's definitely a party to mine, even though they didn't list him because he was the lawyer But that absence matters, folks. Disciplinary complaints grounded in litigation conduct ordinarily follow judicial findings. They do not precede them. They do not substitute for them, and they do not arise only after complaining attorney's own conduct has been questioned. I mean, lacking that pattern, the pattern is right there. I see it. When the timeline's laid out honestly, the pattern becomes unavoidable. An internal police process closed ranks and issued a conclusory closure letter, and a prosecutor with a documented adversarial history declined to recuse herself and himself, really. Procedural objections were raised and resolved in court. Criticisms followed. Only then did the disciplinary machinery engage, using arguments that the court had already rendered irrelevant. That's not how a neutral system would behave when correcting genuine misconduct, right? This is how institutions behave when they stop answering substance and start policing the person who forced the substance into the view of the public. That's why the next friend argument can't stand on its own. It survives only if the timeline is ignored. Once the sequence is restored, the argument reveals itself not as doctrine applied, but as doctrine repurposed. And that's the point where the story stops being about habeas procedure and starts being about retaliation disguised as regurgitation against me. Assholes. All right. That's going to bring us to our next section, part 5 of this little series here. We're going to do another quick little break for sponsorship, and then I'll be right back. Hey there, folks. If you really want to know what's happening in your hometown, the place to go is Lorain Daily and Vermilion Daily. From city council and school boards to local businesses, community events, and neighborhood stories, these outlets cover what the big media ignores. This is hyper-local news for real people in real communities. Visit Lorain Daily and VermilionDaily.com today. Read it, share it, support local journalism, because your community deserves coverage that actually lives here. All right, folks, that brings us back to the top here in part 5. What the court found, or at least never found, were allegations, are not findings, right? What anchors this entire episode in reality rather than rhetoric is the simplest fact of all. No court ever found misconduct, ever. That statement is not evasive. It is precise. It is grounded in the record. And it's fatal to the theory advanced in the unauthorized practice of law complaint. At no point did any judge find I lied to the court. At no point did any court find that I engaged in UPL. At no point did any court refer my conduct to a disciplinary body for investigation, review, or sanction. There's no order, no entry, no transcript, no opinion that reaches any such conclusion whatsoever. What exists instead are accusations embedded in motion practice, right? That distinction matters because, from my understanding of what Ohio law brings, is the basic principle of adjudication. Allegations by counsel are not evidence. Shit, they're not even findings. They're definitely not facts. They're just advocacy disguised as opinion, or opinion disguised as advocacy, because the difference between advocacy and adjudication is clean and clear. In adversarial litigation, attorneys accuse each other of things constantly, right? They accuse opposing parties of bad faith. They accuse witnesses of lack of credibility. They accuse filings of being improper, untimely, or procedurally defective. None of those accusations have legal force at all, unless and until a court adopts them and through finding. Here, that's never happened. The state objected. Well, the state, being Lee Prue, objected to us filing with me as the next friend. And the court ended up dismissing our filing. While that was happening, Garen got the other one. Now, the court didn't issue a sanction. The court didn't issue a warning. The court didn't issue a referral. The court didn't include language suggesting deception, abuse, or misconduct. The dismissal resolved the procedural posture and nothing more. Should have never happened, to be honest. But they did what they did, and we anticipated that move. And by doing so, Robert anticipated that they were going to do this. So he sent Garen down to the jail to get this done, right? See, because that's what a good lawyer does. He saw in advance the play they were going to make, and so he authorized Garen to go down and do this. So Garen goes down and does this. It's not me. I'm no longer involved at all. I'm not Next Friend anymore because they kicked my ass to the curb. Even though legally everyone knew that I was legally able to do it, they were just trying to delay to keep him there as long as possible. When I mean James. So, none of that matters. I was there to get him out of jail because he was there illegally. But attempt to recharacterize that dismissal later as an implicit finding of wrongdoing are not supported by the record, their narrative reconstruction, right? Not judicial history. The significance of silence, judicial silence, not ambiguity, folks. It's disciplinary context. Silence has meaning. Courts know how to signal concern. They know how to issue show cause orders. They know how to refer matters to disciplinary authorities. They know how to make credibility findings against someone. They know how to impose sanctions when they believe a litigant or a participant has crossed the line. None of that occurred here. The absence of any judicial action against me is not an oversight. It's the natural result of a court addressing a procedural issue, disposing of it, and moving the fuck on. Courts do not quietly outsource discipline through implication or through APAs. They act openly, and they don't act at all. The record reflects non-action because there was nothing to act upon. The case's actual resolution, the habeas petitioner was released. The matter concluded. There was no adverse ruling against me. There was no finding that my conduct tainted the proceedings, no finding against my attorney, and no finding against, my attorney who also happened to be, James's attorney. There was no suggestion that the outcome was compromised or improperly influenced. That procedural posture matters because it undercuts the premise that some ongoing harm required retroactive intervention. Courts are not indifferent to misconduct that affects outcomes. If anything of the sort had occurred, it would have appeared in the disposition, and it didn't. Now, the attempt to later manufacture a disciplinary issue where none existed and where the court itself found none is not a correction of an error. It's substitution of an accusation for an adjudication. That's why this matter is beyond me. The distinction is not academic. If allegations in motion practice could later be repurposed as disciplinary findings without judicial adoption, then any licensed professional who assists in litigation would be subject to after-the-fact punishment based solely on the opposing attorney's displeasure. That is not how the system is designed to function. Discipline follows findings. It does not precede them. And it damn sure doesn't replace them. And it does not arise only after the accused has challenged the conduct of the accuser. Here the court did its job. It resolved what was before it. It did not condemn. It did not accuse. It did not refer. Everything that followed occurred outside the courtroom, after the courtroom had already spoken through its silence. And that silence is not empty. It's the most telling part of the record. But, this is why it matters for most licensed professionals, because when litigation accusations become licensing threats. I'm licensed social worker, right? It's up there on the wall. That fact does not sit in a vacuum. It carries a statutory obligation, ethical duties, reporting requirements, and a permanent regulatory record that follows me across employers, courts, and agencies. So when an officer of the court in Lee Prue accuses me of dishonesty in a filing, that accusation doesn't just stop at the edge of the case caption. It travels. It's not in a bubble. It holds weight. For licensed professionals, credibility is not a rhetorical concept. It's currency. James McCann knew that. Allegations of dishonesty are not abstract insults. They're triggers. They implicate ethics boards, licensure removal, employment screening, court credibility, assessments, and future professional relationships. I used to be able to work for the courts. Not now. Even when unproven, they create risk delay defensive obligations that do not exist for unlicensed participants. I notice I've applied for jobs with the county and don't even get callbacks ever. That's how I can prove it, just for the record, in case anybody was questioning. I've applied for other jobs and not gotten offers for any of them because all I have to do is ask around. That's why accuracy matters at a level that casual observers often underestimate. When a prosecutor uses language like that and suggests that I've been lying under oath, false statements, or bad faith, that language has consequences beyond the motion being argued. It becomes something that must be disclosed, explained, rebutted, and preserved against future misuse. Silence is not an option for me because silence can later be framed as being a acquiescence. Can later be framed as acquiescence. I hate that word. I'm legally obligated to protect my license. That obligation does not make me aggressive. It makes me responsible. Because, that candor thing, it runs in both directions. Licensed professionals are not required to act with, are required to act with candor towards tribunals, boards, and the public. That duty is drilled into us from the beginning. What is less often acknowledged is that officers of the court carry reciprocal obligations when they speak about licensed professionals and official filings. That's her. Candor is not satisfied by selective quotation. Not satisfied by omission of context. It's not satisfied by implying misconduct where no court has found any. When a prosecutor accuses a licensed professional of dishonesty without a judicial finding, that accusation must be grounded in fact, not inference, and law, not frustration, right? The decision matters because the licensing systems are not built to adjudicate litigation disputes. They're built to assess ethical violations. When litigation rhetoric is repackaged as ethical concern, the line between advocacy and professional harm disappears. And that's how these systems are meant to function. That's not how they're meant to function, right? The weaponization problem, disciplinary mechanisms exist to protect the public, not punish the adversary. They're not appellate tools. They're not substitutes for unfavorable rulings. They're not pressure points to be deployed when litigation doesn't go as planned. When disciplinary complaints are filed immediately after a lawyer's conduct is challenged, 7 days after I filed an email questioning her ability to be fair in regards to me, 7 days, or immediately after a procedural issue has been recently cured, the timing is not, it actually becomes the evidence. Not evidence of misconduct by the respondent, but evidence of a motive by the complainant. Licensed professionals are uniquely vulnerable to this kind of tactic because the mere existence of a complaint creates work, stress, reputational drag. Regardless of the outcome, the process itself becomes the punishment. That reality imposes a heightened duty of restraint on those who control access to disciplinary channels. Using those channels as leverage undermines the legitimacy and chills the lawful participation in the justice system. That goes why correction is not optional, right? When misstatements affect my professional standing, I don't have the luxury of just letting it pass, right? I'm not able to just say, oh, no big deal. I'm required to correct the record. I'm required to preserve the context. I'm required to push back against narratives that could later be misrepresented as findings. That's not defensiveness. It's compliance with my own professional obligations. If I allowed allegations of dishonesty to remain unchallenged in official filings, I would be failing in my duty to my own license, to my clients, and to any court or other agency that later relies on that record. The expectation is that a licensed professional should absorb reputational harm quietly for the sake of institutional convenience is incompatible with ethical practice. Just is. The broader implication here is not really just about me. If prosecutors are permitted to convert litigation disputes into licensing threats without judicial findings, right, then every licensed professional who assists in court proceedings becomes vulnerable. Any social worker, counselor, expert, investigator, and advocate would be all operate under the shadow of retaliatory discipline when their involvement becomes inconvenient. It's not accountability. That is deterrence by fear. Disciplinary systems lose credibility when they're used to settle scores. Courts lose credibility when their silence is later treated as implied condemnation. And licensed professionals lose trust in institutions that are supposed to distinguish between advocacy and ethics. That's why this matters. Not because of ego, not because of personality, but because the boundary between lawful litigation and professional retaliation must be defended, or it's going to be erased. Once it's erased, no license is truly going to be safe. And what this means for people who are licensed is that when litigation accusations become licensing threats, I am a social worker here in the state. That fact doesn't sit in a vacuum. Wait a minute. My bad. I just don't understand why, people don't understand how this affects everything. I don't understand how people can't see that it's not hypothetical, right? It's not speculation. It's not inference. It's documented sequence at this point. I've been reported to 3 separate licensing and regulatory boards, all within like 3 years, each time following periods in which I personally challenged government conduct through lawful means, public records requests, litigation, or court filings. Each report's been followed the same arc. Allegations are framed around character rather than adjudicated facts. Context is omitted, procedural outcomes ignored, and then the timing coincides with findings of misconduct. Not with findings of misconduct, but with resistance to scrutiny. One board complaint followed challenges raised through my own professional regulatory body. The social work one. Another one, disputes involving credentialing and scope, which was another licensing board, which was my CDCA. And then this most recent complaint followed direct criticism of a prosecutor's filings and a demand for recusal grounded in documented bias and mischaracterization. In none of these instances did a court issue a finding of dishonesty. In none of these instances did a judge refer the matter for discipline. None of these instances did the underlying allegations survive judicial testing. What changed was not my conduct. What changed was the willingness of the institutional actors to tolerate scrutiny. When complaints migrate from forum to forum after prior avenues fail, this is not accountability, it's escalation. When the disciplinary systems are invoked serially after litigation pressure is applied, that's not coincidence, it's pattern. And when the same individual is repeatedly targeted across unrelated boards, the social work board, the drug and alcohol board, and now the lawyer board, despite the absence of adverse findings, the issue is no longer whether a particular complaint has merit. The issue becomes whether the disciplinary process is being repurposed as tools of attrition against a person who refuses to stop asking uncomfortable questions. That line's been crossed now, folks. It's no longer about a single prosecutor, single filing, single case. It's about the integrity of the regulatory systems that are supposed to protect the public, not exhaust the individual. It's about whether licensed professionals are permitted to participate in the justice system without facing cascading retaliation across multiple oversight bodies simply for doing their ethical duty. That's why this record matters. That's why this timing matters. That's why this cannot be dismissed as isolated or accidental. Because, once a pattern's visible, pretending it's not there doesn't, make it go away. It becomes your choice. that brings us to the end of our little fun time tonight here. I did actually keep it about 90 minutes tonight. So this complaint does not arise from unauthorized practice of law, right? It arises from lawful participation in a judicial proceeding. It arises from clerical and menstrual assistance provided and performed openly under the direction and control of a licensed counselor, a licensed lawyer. And in a habeas matter where access to the courts was constrained by incarceration and later fully cured by ratification and by the appearance of counsel of record. It arises from criticism that could not be answered on the merits and therefore had to be displaced in another forum. What must be said plainly, because anything softer misstates the gravity of what occurred, is that the filing of UPL on unauthorized practice of law complaint is not a neutral administrative gesture. It's an accusation of unlawful conduct. Under Ohio law, unauthorized practice is treated as a legal activity. It's enforced through a quasi-prosecutorial process. It carries reputational consequences, collateral consequences, and the implied assertion that the accused knowingly crossed a legal boundary reserved to licensed attorneys. Now, when an assistant prosecuting attorney makes that allegation, she is accusing a private citizen and a licensed professional of committing a crime in substance, even if the accusation is routed through a disciplinary mechanism rather than a criminal docket. That matters because no court ever found that I engaged in unauthorized practice. Nope, not one. No court ever found that I lied. Nope, not one. No court ever referred anything for discipline. Not one. No judge made a finding of misconduct. Not one. The accusations existed only in a motion, practice, and they were never adjudicated. The habeas petitioner was released. The case concluded without any adverse judicial determination against me. The legal issues the complaint later tried to resurrect had already been cured, rendered moot, or displaced by the entity, by the entry of licensed counsel as attorney of record. Who, again, I have to point out, was on the record with me, because, again, I didn't go at this alone ever. Robert contacted me, not the other way around. He was always in charge. The timing makes the nature of the accusation impossible to ignore. I firmly challenge the accuracy and propriety of Ms. Prue's filings against me because, she wrote some nasty shit about me and Bob showed me, and I was like, ew. I asked for recusal from any of my moving forward, my matters, right? Not the one he was dealing with, but anything I was dealing with, because I had dealt with her before in all these other records cases. So I don't want you on any of my filings. Like, you seem to have a problem with me. I put those concerns in writing. I emailed them to her boss and her and my attorney. I preserved it all for the record. 7 days after that, this complaint was filed. No new facts, no new court referral, no judicial finding. The only intervening event was that her conduct had been questioned. That's not coincidence. That's sequence. And sequence matters when a government lawyer escalates from litigation advocacy into accusation of criminal conduct. And that's why the misuse of habeas doctrine and the next friend standing cannot be dismissed as legal disagreement. Those doctrines were revived only after the underlying procedural posture had already changed, after any arguable defect had been cured, after licensed counsel had assumed full control of the case, which, again, he had it from the beginning, but it just transferred me out and James completely in, because we got him on notary, because we took one down there to cure any issues that the state was claiming existed. The law is not being applied to solve a problem. It was being repurposed to justify an accusation after the problem no longer existed. And that's why this episode cannot be separated from what followed. I've been reported to 3 separate licensing boards or regulatory boards. Each report follows the same fucking pattern. Character accusations and assassinations, untethered from any judicial or adjudicated facts. Allegations advanced without filings. Escalation into professional discipline after other avenues failed. For a licensed social worker, these are not abstract harms. They implicate credentialing, employment, and future practice. They are designed to follow you beyond the courtroom. Disciplinary systems exist to protect the public and preserve the integrity of professions they regulate. They do not exist to be used as substitutes for, adverse rulings. They do not exist to launder unproven accusations into permanent reputational damage. And they damn sure don't exist to be deployed as pressure tools after criticism is raised and cannot be rebutted on the record, right? The ops closure with McCann's thing and whatever the fuck they're talking about over at LPD told us how the institution closes ranks internally through administrative language that sounds final when avoiding factual engagement. Well, the UPL complaint shows what happens when that closure is challenged externally, when the dispute moves from internal review to external retaliation, and when legal doctrine is stretched to the support an accusation no court has ever made. And so, together, these actions tell a single story. Not about unauthorized practice, not about ethics, not about, a little bit about ethics, not about protecting the public. They tell a story about resistance, escalation to the misuse of authority when accountability is demanded. And once the timeline's laid out honestly, once the sequence is visible, once the nature of the accusation is called what it is, the story can't be unseen. And that brings us to the end of tonight's episode. I want to thank you guys for tuning in. My name's Aaron Knapp. I'm here whenever I get here, but I appreciate you guys tuning in for accountability. Remember, law enforcement, you guys be lawful, not awful. Everybody out there, stay safe, and we'll see you guys next time.
Unplug with Nap. Yeah, we cut through the noise. No script, no leash, no polished decoys. Broadcasting without permission. We don't ask. We lift the curtain and we drop the mask. Unplug with Nap. Yeah, we cut through the noise. No script, no leash, no polished decoys. Broadcasting without permission. We don't ask. We lift the curtain and we drop the mask.